it's 6 o'clock, 6:01 even, so we'll get started. Chris reminded me of his name, but will you guys remind me of your name? Rachel. Cole. Okay. Well, thank you guys for coming. You already know me, so I won't spend a whole bunch of time on introducing myself, but Ron is filming this, and it will be on MCAT for, I guess, online for access, so I'll just briefly tell you some of the stuff you guys already heard from me for the, well, it's a good review, and why not? So this is registering a copyright. We're going to do some electronic, or we have some paper options to do a workshop on copyright registration. To get started, while you're kind of have some idle time if you haven't done it already, I would like you to go to copyright.gov and set up an account, because if you do that while I'm talking, when we get to the actual work through the process phase, you'll be good to go and ready to do it. Chris, you have a laptop?
Yeah.
Fantastic, okay. So you guys have met me before. I'm Sarah Rhodes. I am doing a series of intellectual property presentations. This is the first one of this series, the Copyright Registration Workshop. But then in January, I also have Trademark Fundamentals, where I dig a little deeper into trademarks and step through the actual trademark application, both at the state level and at the US PTO level. And then in February, I'll do an introduction to patents and some of the first steps in patents and talk about the duration for patents. So this workshop and those future presentations are for information only and do not create any sort of attorney-client relationship. So tonight, we're going to talk about what is a copyright, and I will breeze through that because it's very much a review for you in the room, and what works are protected, why and when to register a copyright, where and how to complete the registration process, and then the actual application. So what is a copyright? It's an intellectual property right that comes from the US Constitution, where our forefathers thought it was very important to have both protections for patents and copyrights, and wanted Congress to have the power to promote, through the enactment of laws, the progress of science and the arts, particularly the useful arts. And they expressly wanted them to have, them being Congress, have the right to give authors and inventors an exclusive right to their respective writings and discoveries for a limited period of time. So today we have our US copyright law. This version that we are living in today started in 1976, and it provides for copyright as a legal protection for original works of authorship fixed in any tangible medium of expression. So that, we will see, includes many, many types of works. And what copyright does that's pretty unique is that it gives authors and artists a bundle of rights, and the exclusive right to divvy out those bundle of rights. So reproduction means the right to copy. Adaptation means to make derivative works. Distribution means to sell those. And then, of course, public performance, public display, and digital audio transmission are all public dissemination of the works. Exclusivity in copyright is a legal monopoly to an author's protected work. That exclusive right to do or authorize others to do specific things with the work dovetails back to the bundle of rights I told you about. So you have the sole right to reproduce, to distribute, to make derivative works, and to distribute copies to the public. That exclusive right can be transferred in whole or part. So if you think of like pickup sticks, you can hand out individual pieces of the sticks, or you can give the whole bundle away. But if you do give the whole bundle away and mean for that to be a way of transferring that bundle not to be coming back to you, then that must be in writing. Our current copyright term in the United States is the life of the author, when that person is a natural human, plus 70 years. So after you die, your copyright will subsist another 70 years. There's also protection for works of authorship that are not owned originally by a natural person. So this is like when there's a work made for hire or anonymous or pseudonymous work, then the duration of the copyright is defined by 95 years from publication or 120 years from the date of creation, whichever expires first. It makes sense to have this other type of duration because it can't be defined by death in that situation. So they're a very specific time frame for those types of works. The duration of copyright has evolved over the life of our United States copyright law. Originally, it was only for 14 years and renewable for another 14 years. Then the law changed it just to be a straight 28 years, putting those two together. Then the law changed it to be 28 years and had the option for some renewals and a lot of hoops you had to jump through to get that length of term. And in 1978, we loosened the strictness of our US copyright law, changed it to 50 years after the life of the author, and in 1998, that was extended to 70 years after the life of the author. So copyright protects which types of work? Those are original works fixed in a tangible form, and that can be a lot of things in our world. Of course, we recognize music and books and movies and artwork, but it can also, of course, attach to photographs and television shows and sculptures. There's also some a little less commonly known versions of architecture and software. So to be original, something has to be independently created by the author and not copied from others. This has traditionally been a very low level of originality in the United States. It can vary around the world how much originality is required. But in the US, we require independent creation and at least a modicum of creativity, which means really at least some minimal degree of creativity. And to be fixed under US law, they must be fixed in a tangible form of expression, and a live performance would not count as a copyright protected work unless it is also recorded in some manner. Fixation does not need to be directly perceptible to like the human eye, so long as it may be communicated with the aid of a machine or a device. The broad categories of copyright protection, and this is very important as we move forward into our application process, are literary works, musical works, sound recordings, dramatic works, choreographic works, and then pictorial, graphic, and sculptural works, so those are visual arts, motion pictures, architectural works, and then works that are created based on pre-existing works. Things that are not protected are any short phrases, titles, even titles of books are not protected under copyright. Names are not protected, facts are not protected. There is express exclusion for font or typeface, and the mere listing of ingredients or content cannot be protected. Very importantly, ideas cannot be protected with copyright. It is absolutely vital that only the expression of an idea can have copyright attached to it. So that way we're not monopolizing ideas and preventing other artists from attempting to do something similar to something that came before. Works also not protected by copyright are those already in the public domain, either by dedication to the public or because they have expired. Their duration of protection has expired. Or if they're in the public domain because they are works by the United States government. So why and when would you want to register a copyright? And this is very important, and frankly the reason that I'm here tonight is the difference between protection and enforcement. There's no ability to enforce your copyrights unless you go through the process of registration. So in the United States, copyright protection is automatic. So as soon as you have met those criteria of being original and reduced to a tangible form, so fixed in a tangible form, you have copyright. You don't have to publish it. It could stay private in a book on your desk forever. It's still protected by copyright. There is no registration required unless you ever need to enforce your rights. I do want to say very briefly that there's no such thing as a poor man's copyright. That's just a mythical theory that arose in the lore of the United States over time. What that means is people usually refer to a poor man's copyright when they write themselves a letter and include their artwork in that letter and think somehow that gives them protection, but it does not. So why should you register your copyright? It is absolutely required if you ever want to file a federal copyright infringement lawsuit. It also is basically required if you ever want to send a cease and desist letter. And the reason that I say basically required is because it makes that cease and desist letter credible. You have the right to take the next step, which is the first bullet here in filing the infringement suit. Therefore, people will believe you when you send them a cease and desist letter that it's a real right and they must stop, or they will be sued. It creates a public record of authorship, ownership, and if you choose, makes a public record of the permissions contact to use a particular registered work. It creates official evidence of your asset for you, for your business, and for your heirs, because as I said, it's good for 70 years after you've passed away. And if it's timely registered, it increases the money you can recover from copyright infringers. So if you have to take step 1, which is the lawsuit, you actually get to recover more in terms of damages. Now, when should I register? I'm very happy that you all are here tonight so that I can clarify something that I told you before. So timing is everything when it comes to registration. It is best to register within 3 months of publication. There are a few instances that hardly ever occur where you could register within 1 month of discovering an infringement. But unless you qualify for those few exceptions, your registration needs to happen before any infringement occurs. And in the real world, this never happens. Like, you would never, it would have to be a terrible coincidence, a good terrible coincidence, that you happen to register before an infringement occurred if you hadn't been timely in the first place. But if you do register before infringement, you can still have the opportunity for enhanced damages that we'll talk about. And then at least within 5 years of creation, so that you're creating that formal legal record of ownership of the work. Copyright registration is still possible anytime during the term of the copyright, even after you've passed away. The most important reasons to timely register is that you get to claim statutory damages and attorney's fees if you have to bring someone to federal court. This is only possible if it's registered within 3 months, and as I said, in most cases it has to be registered prior to any infringement of the work. Otherwise, you still get damages. It's just that you only get actual damages and profits and no attorney's fees, which is probably more expensive than any of those things. If you register within 5 years of registration, you still get a pretty good standing in court because you have evidence, and prima facie means on its face evidence, of the validity of your copyright and that the facts stated in that registration certificate are true. So it shifts the burden to the defendant to prove somehow if they're not true. There's even more reasons to register because you have the opportunity to record your copyright registration with the United States Customs and Border Patrol in order to keep fakes out, unauthorized copies out of our borders. As I said, it makes it easier to enforce in the US, but it also makes it easier to enforce in foreign courts, should you need to. And then a really good reason to register is that you can be found by others for permission purposes and for licensing purposes. And that you can also collect royalties and enforce your rights outside of court, like I said, because you have the threat looming over an infringer of actual federal court. And then in limited circumstances, it can implicate potential criminal penalties. So I know you guys have heard me say this. Is copyright notice required? No, it's not required, but you should absolutely use it because the general public thinks it's required. And they think if there's no Circle C, then it's not protected by copyright, which as you've learned is not the case, but they don't have a good understanding of that. There's no restriction as far as timing of using a Circle C. You can use it without any registration. You can use it after or before registration, even on unpublished works. It is also beneficial because it identifies the copyright owner, again, for locating you. In court, you can get better damages from the jury or from the judge if you can establish that the defendant is not an innocent infringer. And one way to do that is by having a copyright notice. And so, of course, they knew it was protected by copyright. Or at least they can't have an argument that they didn't know it was protected by copyright. There's also an ability if this thief that I'm telling you about takes steps to intentionally alter the Circle C or other copyright notice, then there's an opportunity for even more enhanced damages under the Digital Millennium Copyright Act. And that's up to $2,500 per infringement, so it can really add up. It's a good idea to also include all rights reserved with any notice where you display your works, including your website, because it has implications internationally in particular. So some examples of how to make your copyright notice look will depend on your medium, of course, But generally, we try to recommend a Circle C, the year of creation or publication, whichever applies, and the owner. For example, Circle C 2021 Susan Jones would be a perfectly acceptable copyright notice. To the extent you have more paper to be able to use or digital space to be able to use, you can explain more completely what the restrictions are that go along with your copyright notice, and that's one example there. So where and how do you complete your registration process? Well, you go to the Copyright Office, and that is the United States Copyright Office, part of the Library of Congress at copyright.gov. In particular, for online registration, you want to go /registration. If you're looking to print forms, you go /forms. In reality, most applications are a hybrid of an online registration and then a printed deposit that we'll talk more about. We call the online registration system ECHO, stands for Electronic Copyright Office. And while it is electronic, it's not terribly user-friendly. So we'll look at that a little bit more. And the good news is there are efforts by the Copyright Office to modernize and make this more user-friendly and, frankly, just look better. So here's what the Copyright Office website looks today. You should have already seen this when you signed up for your ECHO login information, and the registration portal is there, and then ultimately this is the ECHO home screen that we'll look at more in a minute. The overall registration process is less complex than what we see in intellectual property for patents and trademarks. Copyright applications are rarely refused registration, and the processing times can vary quite a lot, depending on if you can do an electronic-only submission or if you have to mail in deposits. On average, pre-COVID, we always said it takes 6 months to get a registration certificate back from the Copyright Office, but that's taking a lot longer than it used to. Hopefully, once COVID boils down or settles down, it'll go back to about 6 months. There's lots of informational resources at the Copyright Office, copyright circulars, a copyright compendium, which has very detailed information that is very useful. And then their online tutorials, they have a whole library of videos to watch for your specific type of artwork medium. In order to file an application, you make a submission to the Copyright Office that includes a complete application, a filing fee that is appropriate for your submission, and a deposit of the work that you're trying to register. However, your particular work, whether it's an electronic work only or if it's a print work and published work, then there's other requirements that we will talk more about. In general, the rule is that you submit one fee and one application for each and every work. And literally every complete fixed original work is a separate work. So a lot of artists can have lots of work over their lifetime. There are exceptions to having to file a separate application for each work, and it's always a good idea to try to qualify for those if you can. Otherwise, it will be a minimum of $45 per application, more often $65 per application. And if you have to do paper, then it's $125 each time. At the end of the registration process, you get a certificate of registration, which is literally about 1 page long. Looks pretty much like this. That's what the Copyright Office will send back to you. And as you can see, it's folded and everything. It's got a line in it. This just comes in a regular envelope. Okay, so to get ready to do the application, it requires some planning and some upfront work to figure out, what do I have to do? How is this going to apply to me? So to get started, the first thing you're going to ask is, do I have to do this in paper, or can I do it through the ECHO system, through the online system? If you've already signed up for the username and password, then you may have already gone through the obstacles of disabling your pop-up blocker, disabling any third-party toolbars, and setting your security settings to medium. Lately, I've had a great deal of trouble getting the ECHO system to work with Chrome, and so I pretty much exclusively use Firefox browser anytime I am working with the Copyright Office system. It used to be pretty user-friendly with Chrome, but some new updates have made it not work well. So if you have Firefox, I recommend Firefox. Perhaps if you have Safari, it will work too. What did you guys use on yours? What's your browser? Safari. Okay. And, okay. Okay, well, if it seems like it's not working correctly, then go back to Firefox because it seems to work the most consistently. You might have to download it. Not surprisingly, if you want to print and view documents and they're Acrobat documents, you'll have to download Reader. In reality, the best thing to do is to copy and paste the whole thing into a Word document. Like when we get to the end, you'll have all of your input, and you'll want to like keep a record of what your input was. Copying and pasting that into Word works better because, again, it doesn't play really nice with the browsers, and so when you go to print it to PDF, things get cut off and lost. Okay, so hopefully you don't have to do paper forms, but if you do have to do paper forms because of your type of artwork or for other reasons, like the type of, if you're doing a renewal or some other type of registration or licensing recordation, you can get paper forms from the U.S. Copyright Office upon request, or you can print them if you have that capability through the internet. Paper forms have the same basic information, so if you're filling one of those out, you have to pick the right type of form, which we're going to go through this for ECHO, and then you just fill out the exact same information that we'll talk about today that goes into the ECHO system. So you should know the right answers for the paper forms once we're done here. Okay, so for the ECHO application, you create your login information and your password. I strongly encourage you, I should have said this at the top, but when you do create your login information, put all of your current actual information in, your actual address, your legal name, your real name, all of that, because it'll make the next steps easier. You want to select and complete the right type of application, which I hope to help you figure out today. There will be a series of screens and prompts with information to help you make that. There's also lots of opportunities for pop-ups. Like anytime there's underlined words in ECHO, it means that it will pop up additional information and tutorials occasionally. The initial choice in ECHO is very important, as I will show you in the opening screens. You have to get to the right location from the top, which is why we spend this time talking about planning ahead for what you're going to register. And then you also need to plan for making a payment to them. How are you going to do that? As far as I know, they don't accept Venmo up to this point, but they do accept credit cards, debit cards, electronic funds transfers like regular ACH bank transfers. And if you are going to be a prolific copyright registration filer, then you can set up a deposit account that you pre-fill with money, which could be a nice alternative to Venmo if it's kind of an analog to Venmo. You pre-fund the account and then you can just debit away from it. You also need to prepare to send in your work. Be prepared that if you have to, print copies, how are you going to print those copies? What are they going to look like? You want them to be very nice copies if you have to send in copies. As far as preparing for a digital upload, you really want to have all of your file names saved very conscientiously from the beginning. So have a dedicated folder. This is my copyright registration on December 7th, 2021. And it already has all of the information that you plan to upload in it. When we get to the end, you'll see why that's so important, but it keeps you from accidentally uploading some photo that you didn't mean to upload, or your midterm paper or whatever. So if you have a nice little repository of exactly what you're planning to file in its very own place, that's great. If you also have already zipped it, like created a zip file from it, even better, but at least have a dedicated folder where the work that you're intending to register is all by its lonesome and ready to go. There are specific types of claims that can be filed through ECHO. These are most of what we see in the real world. Literary works are going to be every type of written work of visual arts. Those are the two big ones. And then the third one that we'll see a lot too is sound recordings. Those are the ones, at least in my world, that I see the most. But there's also opportunity for serials and unpublished collections, works of performing arts, motion pictures, audiovisual works, photographs, and then newsletters. Serials could be like blogs, newspaper issues as well, which are primarily electronic anymore. Most of everything on this list is going to be a hybrid electronic application, unless it can qualify for some exception. And if it's not listed above, then it probably has to be completed in paper. Okay, so to get into the copyright.com registration system, you can do it a couple ways. You guys have probably already figured this out, but there's a registration drop down that then you can click on registration. You can also go through the register your work section here. So that when you click the drop down, then it says register your work through this registration portal. And this is the registration portal. And then you'll click on this blue rectangular tab to say enter the ecosystem. So now the work that you did at the top is important. Here is where you will enter your user ID and password. Hopefully this part is easy. And you'll get to enter Echo. And this is the fork in the road, so to speak, of where you have to decide what you're registering and pick the right path from the beginning. So there's the standard application they have made. This has changed over time, but as it is now, they kind of isolate it because most works that can qualify for registration through Echo are going to be a standard application. If it's not a standard application, or if you're hoping that you can qualify for groups of works, then you look under other registration options, and they emphasize the restrictions apply. The options include certain groups of published works, groups of photographs, groups of unpublished works, one work by one author, or if there's some correction needed. So formerly, Echo would have this register one work by one author. It's called a single application, and I'll talk about it more here. That used to stand up here too, but I think they had a lot of pushback. But I think that the ecosystem is really meant to be used quite a lot by the, just artists generally creating their own work and owning their own work. And so hopefully, for the people in this room, a lot of times registering one work by one author will be a good option. And the reason that that's nice and important, particularly if you're creating a lot of works, is that it's $20 cheaper than having to do a standard application or one of these other types of applications. So I'll talk about those other ones some more too, but the single application is ideally where you want to fit because you get $20 off. Now, that's only true if you're only registering one work. If you're doing a large group of photographs, you want to get as many as you can for your registration fee, and that is going to be $65. It's not going to qualify for this $45. But if you have one photo that is very popular and you own it and you created it, so you created it, you're the author, you own it, so you're the claimant, and you can submit it according to how they require it, then you can get $45, $20 off the regular fee. There's many types of works that qualify for a single application. One script, one novel, one motion picture, one sound recording, one photograph. That literally has to be one, yeah.
Downside, maybe you do have a photo that's a little more popular, but just throwing it in with the group, is there any disadvantage to that?
Not under the current way that they have the group of photographs set up. There's no disadvantage, but there might be advantages because perhaps it has a particular title that's recognizable. And so when people go to search for that title, that might be the only way they find it. So there could be benefits, but probably no negative consequence. Does that make sense? Yeah. So lots of things not eligible for single applications. Anything that's more than one work, anything that's also more than one work, has more than one author, if there's joint works, if there's multiple performers, if we've got a unit of publication, that's more than one thing. If we've got a group, that's more than one thing. A database is not going to qualify. A website's not going to qualify, even though in theory they're one work. So it's pretty rare that a single application will apply, but for individual authors and artists, it's a really good option. So most works are going to fall under the standard application. Can be original works, it can be derivative works, collective works, compilations. I talked about websites. This particular application is not used for groups. What I want to emphasize here is that we are talking about choosing your path. That's where We're diving in to choose which path, which thing do you click to get into the right section of Echo. And these are the standard application exceptions because we don't do standard application because they have their own button to click. So certain groups of published works, we will select that if they are a group of issues of the same serial, the same newspaper, a newsletter, or periodicals, then you select group of published works. If it's a group of photographs, now this is a fork in the road for you. Once you select group of photographs, you might have noticed that it doesn't say at that point published or unpublished. But the first thing you will have to answer once you select group of photographs, the next question that they ask you is it published or not published. So when you're preparing to do a group of photographs, they can all be published as long as they're in the same calendar year. They were published in the same calendar year. Then they can still qualify.
What if it was like a New Year's event? You know, you took photos, it's all from the same event, but it like crosses over the year.
Oh my gosh, that's funny. I don't know. 11:59, 12:01. Well, I would say to that you're going to have a good answer to this too, but I'm going to say they're not published the same year. They were created in 2 different years, which I think also kicks them out of this too, because your question still applies in that situation. But that's hardly ever happened, but I'm sure it will in your world. So it's a thought puzzle for sure. Yeah. No, just turn it down. No. So once you have selected, you need to make sure you have 750 or less photos, or else plan to file more than one application. That's the key. You might have multiple $750 sets or 750 photo sets that you'll be submitting for $65 each. There's very strict requirements on sequentially numbering your list of photographs so that when an examiner picks it up, they're called registration specialists. When they pick it up at the Copyright Office, they can understand what it is you're registering and confirm that it is a complete application. And numbers are just easier to follow when you're dealing with this volume of work. You are allowed to name. You can have a title and a file name for each of your photographs, but they need to be sequentially numbered. It is a very good idea and actually it says it must contain the title and the group of the case number assigned to your application. Remind me when we get there, I'll tell you how to find your case number. It's at the top of Echo. And then this link we can dig into if we have time, and we probably will for you guys, that shows some very specific requirements of what they want this list to look like. And it's actually a template. There's a template you can download. I think it's Excel. Do you use Excel on Macs? There's probably another CSV or some sort of spreadsheet format that will import. So another option, again, in this same fork in the road slide is to register a group of unpublished works. There's very strict requirements. They don't get the benefit of like photos, where they have to have 10 or fewer in their group of unpublished works. The place that this has come up in my world is like for a line of t-shirts. So if we've got a very unique set of imagery that's going to be ultimately printed on t-shirts, then before they get published, we can compile up to 10 of them and get a registration for $65. If we wait until after they're published, then each one has to be filed individually, so it's $65 each. You can submit up to 10 works, but they all have to be the same kind of work. So the example here is you cannot register one poem and one song and one drawing and qualify for this group of unpublished works. They have to be all the same kind, either all songs, all poems, all drawings, in order to qualify for this. And then they have to be created by the same author or co-authors. You're allowed to have multiples in this instance. And the author and the claimant for each work must be the same person or organization. They don't have to be the same between them, but they have to be consistent for all the works in the group. So how do you decide if your work is published? It's very difficult. But for some types of works, it's more clear. When we're dealing with a book or a newspaper, we very clearly understand that when you purchase one of those, in the copyright world, that means that it is published. A song, perhaps you're accessing through streaming or some other format, still is going to qualify for a publication because it's being shared. The actual US copyright law uses the terminology of rental, lease, or lending when it comes to a transfer of ownership. But those aren't words we actually use in copyright, so it's a little bit archaic. We typically refer to licensing, or like for music, we say streaming. You know, it's like this transitory lending that's going on in a lot of copyright situations. And that's kind of true for software too, although there is typically a license that you click quickly past where you're agreeing to use a software within the terms of a licensing agreement. But if the software is provided, there's a little bit of gray area whether or not it's for download. If it's for download, then it probably is published. If it's just for accessing on kind of a non-downloadable basis, then perhaps it doesn't qualify for publication, but it's going to be very fact-specific. Sometimes offering to distribute copies for further distribution can put you into publication even if you don't actually consummate a sale or anything like that. If it's an offer for public display like a movie, then the actual offering of copies to movie theaters for public showing is publication. When we're dealing with works that are displayed online only, a lot of intent will come into whether or not a work is published. So if we have a website that the website is full of blogs, and the blog articles aren't necessarily out there for people to download or keep copies of, perhaps they just come click at it and look at the blog and read it and go away. I would say if that blog also has quite a lot of pop-up advertising and money that the blog is making through site visits, then that's probably going to qualify as publication because it's an actual, come read my blog and I'll make money. You get to read my blog and I make money. So there's a lot of gray area with online sorts of publications, whether they count for the copyright definition of published or not. Very easier bright line test to tell is if you have a website where you're offering to sell your prints, then that is an offer for sale, that is publication. You are a published work, and you'll be selecting that when you go through the ECHO process. Yeah?
It's on your website for print, but not all your images are, or only the images that are available to buy for print and published at that point?
You know, it's a great question because in some ways, if you have some things for sale, then you're driving traffic to your website ultimately to make money off of your photos. But I think you'd have a really good argument if you have a set of photos that are not for sale for whatever reason, then they aren't published. Because if you wanted them to be for sale and published, they'd be in your store, and they are not. So I think that, you know, I'm guessing at intent when I make that determination, but it seems like you've made a distinct decision in your mind of what is published and what is not published. So I think you'd have a good argument. And it's kind of, perhaps maybe it's for critique or for discussions that the ones aren't for sale, and there's been decisions saying that that's likely not a true publication in the terms of the definition of copyright law. So it's in the mind of the artist a lot of times, which is why it's so difficult to know for sure when we're not dealing with bright lines. So if we're talking about registering an ECHO, and you have to answer this question in ECHO, you should have a really good grasp of what's in your mind about whether it's published or whether you intended it to be published or not. Ideally, you're doing the best you can when you fill out the paper, the ECHO paper, and trying to give the best answers that you can at the time that you fill it out. There's not anyone there to grade you. I will say that if you make a representation in your application and the examiner I told you about picks it up and sees something that's just absolutely inconsistent or just doesn't make sense based on what you've sent in, they will get in touch with you and they'll just ask you, did you mean to say this or did you mean it was not published? And I've had that happen a lot in my career where examiners will contact me and say, what did you mean by this? So it's not the end of the road. If it seems like you've done something wrong, the Copyright Office might help you fix it.
Yeah, like the status changes. Like in that same example, like I'm only selling these limited edition prints of these 3 images for now, but 6 months from now, when the other images have good traction, I allow those for draft like update on the website. What if it's now published and it wasn't before kind of thing?
So it'll depend on the date that you file the application. So it's just like you're taking that capture of time, like right now, as I push submit, as we get to the end of these slides, right now, is it offered for sale? Even if you change your mind in 3 months, you're allowed to do that. Yeah, you're not stuck with it. If you say it's unpublished today, it could be published later. It can still turn into published later. It's just at the time of filing, what's its status today? Yeah.
If you were to submit like an image and a group of other images, can you then later recopyright that by itself?
Yeah, you can, and I'll show you in some of the slides where you would designate that there was an earlier registration number, and sometimes that might be a good thing to do. Kind of going back to your question about, can you do one photograph if it has a lot of fame, and you can extract it and register again. Okay, so public performance by itself might not constitute publication, and when you are providing the date of publication, so on the date that you're filing your application, you decide this work is published. You have to tell the Copyright Office when. When was it published? So you need to go back and look at your website and see when you launched your store, maybe, or see when that status actually became published. If we're talking about a display at a gallery or a display at a cafe where there's a price tag under your work and it's for sale, I mean, the day that it went up on the wall is probably the date of publication. So that might take some work, frequently does take some work in my experience, to recreate what the earliest date of publication is. Ideally, you want it to be literally exact, like December 7th, 2021. But if you can't remember that it was the 7th, you can say December 2021 when the time comes. Okay, so you're ready to log in to Echo, and I think you guys have done this. So here we are. In this particular instance, I have selected the standard application, and that will be indicated here. Recall that when I said, remind me, I'll show you the case number, because it needs to go into your template where you describe your 750 photographs. This is your case number. It just sticks with it. It's for tracking and for everything. It actually ends up on the registration certificate too. So the case number is what you want to, that's where you pull that information. Something that I found when I very first started doing Echo applications, I found very frustrating and inconsistent with other online application forums, is this concept of save for later and continue. And I'll show you that it changes in a minute too. But if you click save for later, it's going to boot you out of the screen. And then you'll have to go back, and it's actually cut off here, but you'll have to navigate back into your work queue and go restart the application. So save for later, we're not going to use today in these slides, but you do have the opportunity if you need to go research your date of publication and you just aren't sure about that, you can freeze. You can freeze the application, save it for later, come back to it in the work queue. So it's a nice thing. I just find it confusing because it's right there at the top. So most of the time you're going to be pressing continue. Once we go into the standard application, you need to select the type of work that you're going to register. So literary work, work of visual arts, sound recording, work of performing arts, motion picture, or single serial. Those are the options under the standard application that we talked about. When you click on these, so if I select literary work, this is going to tell you what a literary work is and make you read through it and confirm that you are talking about one of these wide variety of written works. And then it will make you click here to confirm that that's what you meant to do. Again, making you choose a fork in the road when you go to register the next steps. The other options are work of visual arts. So this would be if you were registering a photograph, not in a set, then you would check work of visual arts. You also have the option of doing sound recordings or works of performing arts, motion pictures or audiovisual works, and a single serial issue. So as I said, once you select one of those options, it's going to tell you what they mean by that option. And then it's going to force you to click this box that you confirm you read the above description and you have selected the appropriate type of work. And then if that all looks good, then you click continue. Now, once you've settled on the type of work, you have to tell the Copyright Office the title of the work that you're registering. So this is one of those strange places that it's almost like a pop-up, even though you disabled your pop-up in your browser. You select New in order to enter the author. Oh, we're doing title first, in order to enter the title. So you have this essentially like a pop-up that says, what is the title of the work that you are going to register? You can look for guidance, like I told you about. These hyperlinks will actually pop up information to give you some guidance on what you might want to call the title of your work. This is generally, like, for a lot of works, it's a descriptive title, but it can be the formal title as well. So like if it's a book, if it's actually a novel, it has a title, then you would put that here, even if it has nothing to do with the contents. Or it can be a descriptive title if you're dealing, like, if you're registering a database, or if you're registering a logo or something like that, it can be descriptive of what is in the work, whatever the title you want to be. So you type the title of the work here, and then here's the confusing thing, for me anyways, when I started doing this. Now you do push save. Now you push save, and when you push save, it's going to take you back to this main, this is how you know you're in the right navigation area, because this means you've gone back, and now you're just in the title, overall title area. You can enter more than one title if you have more than one work that you're populating. But once you've entered one and you pushed save, then it appears here along this line here. And if you've done multiples, there'll be multiple lines that will show up and say what the work's titles are. Now that you're back on this screen with this navigation bar on the left, now you push continue again. So you get to check your progress as you go. It'll say the things that you've completed. Nice little checkbox to make you feel better. Now you get to decide whether or not your work is published. Now I will say again, I chose the standard application in order to make these slides. If you had chosen group of photos, this would have been the first thing that you selected, not the essentially second or third. So has your work been published? It tells you, it gives you the definition of what that is, as clear as it can be, about offering distribute copies to groups of persons for further distribution, or making sales or rentals or leases or lending of your work. So you pick yes or no. Do the best you can. If you say no, also, and then I push continue. If you say no, then it's going to say, okay, that's fine. What year was it completed? This is also, you'll hear me refer to the year of creation. It means year of completion, and you just enter the 4-digit 2021 right there. Here's an opportunity to have a pre-registration number, if there was one. There's also another place I'll show you. So now we click continue. Now if I had said, this is the alternative, if I had said, yes, my work is published, this is what pops up. It still wants to know the year of completion and creation, but now it also wants to know the date of first publication. And you'll notice anytime that it has required information, there's these little red asterisks up there. So it wants to know the first date of publication and the nation, the country of first publication. Those are the required fields on that. Yeah.
With the title for the group works, let's say it's like my 750 like most valuable images from the year. Do you have to name like every single one, or you just say like Cole's photos? Like what do you put in there?
It's really going to be up to you, because you need to keep in mind, Cole, that you're going to have many, many years of these. So I would probably encourage you to lead with 2021 at the beginning, because then when you have 20 years, they'll always be in order. If it's 2031, it'll be 10 below the 2021. So lead with the year, and then say Cole's published photos. Okay. After that? No, but they do require that they be numbered. So they want to know that there's the right number after that too. So you could put the number, it could be 2021-1 through 750, or you could put it at the end. However, the organization makes the most sense in your mind, because you're the one that has to deal with it. is probably going to help. And then also following along with their template of what to do. But that's one suggestion. It also ties into how remember how I said at the beginning to have your work in a folder already, that you will have already planned ahead on that. So the file naming can happen at that point in time too, because if you're selecting, you said your best 750 for the year, the automatic generated, I don't know what you call those, but the number that says IMG, whole bunch of numbers that come after it, whatever auto-generated might not be sequential. If you've picked, this one from various months, they're not going to be in order. Maybe they'll be kind of in order, but they won't be all in a row, I guess is what I mean. So you'll want to kind of make sure you have them in a row so that you don't miss any. So that where's that number 18 that I wanted to make sure was in there too or something. If they're numbered right from the path name itself, it'll be more apparent if you've missed one. And that's why the Copyright Office requires that too, because then they know that they're all there. It's easier to tell that everything you told them was coming, even if it's only 601 instead of 750, they're all there. What you think was there is what they got at the office. So defining your publication happens if you select published work. So here again, you push continue. Now you've completed 3 of the tasks because you have 3 checkboxes. So now the next question is, who are the authors? And you have to name the author of the work. Now, I want to point out that if you set up your username and password at the top and you put in your actual information and your legal name, then you have a very nice option at this point in time and then again in the future to just say add me, and it will kind of automate it for you. It'll put your information in. Whoever's logged in, it'll populate that information. But in my world, I'm not the author. It's usually my client who's the author. So I have to push new, and then I go to this kind of essentially a pop-up screen that asks me to tell them who the individual author or organization is. Again, if it's a work for hire, that's where that would happen. Or the individual author's name. You also have the opportunity to tell the Copyright Office if the author's contribution was work made for hire. And you can choose to leave this blank. You notice there's no red asterisk here. It's not required. But what is required is citizenship or domicile. The things that these tie together is if it's an individual, that's the citizen. And if it's an organization, then it's domicile. And you don't answer both. Now here again, this is that confusing pop-up where you do have to push save in order to get back to the actual navigation. But before we do that, I want to talk a little bit about work made for hire or work for hire. You'll hear both of those. This is an extremely misunderstood concept in the world of copyright, even and particularly among lawyers. There are only two very specific circumstances where work made for hire can apply. The first one is the easiest and the clearest, maybe, depending on the particular type of employer. But if you have an employee who is employed as an artist, like a graphic artist or a staff writer or a staff photographer, and that's their title, then within the scope of their work, they're creating works of art, works of authorship that will belong to the corporation right from the beginning. So if you're inside of ECHO, that's when organization would be the author, and that's the only time when we're in authors, that's the only time the organization would be an author. The second time that work made for hire can apply is if there's a specially ordered and commissioned work, but only if that particular type of work falls within these 9 categories. And even if it is specially commissioned and it is within one of these categories, it still must be in writing before any work commences. And this is the part that never happens in the real world. Very, very rarely lawyers ever get their ducks in a row, or employers get their ducks in a row to get the lawyers involved in time to have something in writing before the work commences. So hardly ever will box 2 apply, very, very rarely. So when the question is the author's contribution work made for hire? It'd be good to leave it blank, but most times it's going to be no, unless one of those 2 situations apply. So this is where if you do have an organization that claims to be the author, then that you would put Yes, because that's the only way that an organization can be an author. And then you would select domicile if it's an organization. The next thing that it will ask you is, what did this author create? And this is important, particularly if you have more than one author. You have to designate, like if it's a band, this is actually a work of performing arts. I went a little rogue here and said, this is like if you had a band, you might have one of your joint authors doing the music, one doing the lyrics. Perhaps there's text outside of the lyrics. I don't know why that would be. And very likely you might have someone else doing the arrangement. And so you're able to designate who authored what within the ecosystem. These options will change depending on what type of work we're dealing with. So like if this is a visual work of art, these options will be photo, jewelry design, map, 2D artwork, might say sculpture or architectural design. So it's just designating, like, there's lots and lots of things that fall under literary work or visual art. So what did this person contribute to this ECHO registration? So there again, you push save to get back to this primary navigation screen. Now, we're still on authors because we haven't told it yet whether we're done with authors. You have the opportunity to add more authors, and they will just continue to list them down here if there's more than one author. I will tell you more about that in a second, but I want to emphasize that you have to push continue to continue. So authorship can be joint, but in order to be joint authors, two authors have to intend that their original contributions, and not just simply the idea, but participate in a creative contribution that is going to be merged into a single work. If that happens, then both joint authors have rights to the work. And unless there's an express agreement to the contrary, each of those individuals can exercise their own jurisdiction, I'll say, over that bundle of sticks that I told you about. So each author can divvy up the sticks however they like. The only thing they cannot do is take the whole bundle and give it away, because there's this coexisting right that the other author has too, and so there's no ability to give away exclusive assignment of the rights. It's just a sharing that's going to go on between the joint authors and their licensees, as long as there's no writing to the contrary. What does have to happen is that the authors have to account to one another. So joint authors, if they make profits, if one author makes a profit, like in the band example I gave you, if they take the work and they go make money off of it, they have to share the proceeds with the other members of the band, unless there's a writing to the contrary. And it's really important because of this, because I actually see lots of joint work disputes as a lawyer. This is where people always have falling outs and didn't think they would have falling outs, and have to have a dispute with each other. So having a writing to clarify what's going to happen to that beautiful work of art once it's completed is really important from the get-go. What's going to happen with ownership and use? Who has the rights to revise the work? I've seen this too, where there's co-authors in a book and one wants to make a new version and one doesn't. Do they have the rights to do that? Yes, they do, unless there's a writing to the contrary. And they may or may not have to share depending on the extent of the derivative work. How are they going to deal with marketing and sharing of the revenue? And what warranties do they want to one another as far as copyright infringement? So really can be easy or not easy, depending on the relationship involved in the work at issue. So that has to tie back. The reason I bring that up is that's when you would want to add another author, and there would be multiple people listed in ECHO. Okay, so the next thing, now see, we got a checkbox for completing the author. The next question we have to answer is, who's the claimant? Claimant is jargon for owner. Who's the owner of this particular work that is being registered? Here again, you have the opportunity, like I told you about, you'd have another opportunity to add me. So if you are the owner of the work you're registering and you've signed in as you can add me. If you're not, if you're doing it for someone else, or if you're like me, doing it for someone else, then you click new, and the pop-up comes up like you're starting to get familiar with now, where you enter either the individual, who's the owner, or the organization that's the owner. You may not select both. You have to pick one or the other, even though they appear to be required, they mean or. Pick one. If for any reason this claimant is not the same as the author that we just completed in the earlier screens, this is where you must tell the Copyright Office how it is that this claimant came to own the work if they're not the author of the work. And that has to be with a transfer statement. Transferring ownership, as I've told you, if you want to take that whole bundle of sticks and you want to actually transfer ownership, that has to be done in writing. And that is the only time where someone other than the author can register the work. That's the only time you'd be in these screens, is if you have that writing of a transfer statement by written agreement, by assignment, by contract. There are some exceptions that don't really come into play as far as like a physical transfer from the author to someone else, but if the author has died, perhaps they've made a writing, like a will, that designates what happens to their artwork after they die, or it can be just by operation of law, the way that the law determines who the heirs will be, and so that would be by inheritance is the selection that would be made in the claimant section. There can be other situations, like sometimes lawsuits, like sometimes divorces, and you just have to tell the Copyright Office what that unique situation is. So now we would have pushed save, because you've gotten very used to that now, and we have our claimant entered, and we will click continue. And now once we do that, we get a checkbox on claimant. Now here's another opportunity where you get to designate if there's a pre-existing registration, a prior registration that we were talking about. If you have a work, and this again is the performing arts, so it's a song, you can exclude claims. So if you're re-recording a song that someone else wrote, you're going to exclude the material of probably all of these things, at least the lyrics and the music, because those are prior existing copyrighted works. Maybe what you're including is your musical arrangement if you're making an original recording of a prior work. So this is your opportunity, and again, these change depending on if you're in a literary work or if you're in a work of visual art, what the options are. So these might say photograph or 2D artwork. If you've got a graphic artist that has created an original beer label, perhaps they have pulled in some clip art. Perhaps they've pulled in a photo and altered it, but they didn't author the photo. So they would exclude the photo here, and they'd say there's new 2D artwork that has been applied to combine those things. So it's where you get to say what's new, what's old. And if the old stuff is subject to a previous registration, like a previous unpublished photograph, this is your opportunity to tell the Copyright Office that. If there's no old material, this screen should be left blank, and none of this is required. So if you have a wholly original work with nothing underlying it that existed before your work, you just skip it and say continue. So now we've completed our limitation of claim, and we get to the rights and permissions. This is optional, and the Copyright Office will caution you that this is very public information. It's intentionally so that when someone researches the Copyright Office records and finds a work that they're interested in licensing or getting permission to make an adaptation of, they know how to find you. So it can be the author, it could be you. You can push add me, and this will populate your information, and it'll be publicly available. It could also be like if you've contracted out this particular responsibility for licensing your work to an organization, you can enter that here. This is changeable. It doesn't have to be permanent. As far as if your address changes, you can update this information. Now we've completed the rights and permissions, and we move on to correspondent. Now this is required, and this is important, because as I told you, if the copyright registration specialist finds something that seems odd in your application, or you've missed a blank somehow and it let you through, or perhaps your upload didn't work, or all kinds of things, they need to know who to call. For my clients, this is me. This is where my information goes. But if you're filling out these applications on your own, you need to put your information in here, and you need to make sure you have your best email address where you will pay attention because it's very important. They only give you 45 days to respond, and they require very specific ways of responding to them, and this is how you tell them where to reach you. It's possible for this to be an organization, but in most cases, this is going to be you. Once you've completed the correspondence address, now you tell the Copyright Office, and this is again required, where to mail the certificate once they grant it. So this will be your information most likely. It's an option, like for me, I put my law firm name under organization name. You can do both. You can do add me, and then this populates. So you can see when you're filling out, and this is meant to be done by artists, when you're filling out your own application, a whole bunch of this is going to be super quick because you're just adding me, and like half of these screens will be completed already. Okay, and then you push continue. And now you've completed your mail certificate. Special handling, what does that mean? It sounds really good. Everybody should have special handling, right? No, not unless you want to pay $800 on top of your other fees. Special handling is an option if there is a pending dispute or a potential dispute, like litigation, like there's copyright infringement going on. If there's a customs matter, like some items have been seized at the border and they're waiting for proof that it's a registration, that it's a registered work and they should keep it out. Or if there's publishing deadlines, then you might want special handling. And in these cases, then there's a lot of money on the line, and $800 doesn't seem like very much money to try to get expedited handling. I think that they project, I don't know during COVID, but generally 2 to 4 weeks for the processing to go through on those, so pretty fast. So you're going to skip special handling and not select that, but you will get a checkbox nonetheless. Now, once you are through special handling, now you get to certify that everything that you told the Copyright Office is true, and you're actually certifying it, like raise your right hand, I promise this is true, to the best of your knowledge. And that's important, to the best of your knowledge. You've done the best you can, you told them your name for real, you gave them your real address and a good email address, all that jazz. So you just enter your name here by typing it, that's effectively signing it. You can have an internal tracking number. So if you do more than one a year, perhaps you would use a tracking number so you know which is which without having to decipher your case number every time. For me, I use, client designations there. You also have the opportunity, this is just a free form fillable box. So if perhaps you filled out something through this process and you just weren't sure that that's what you were supposed to say, or if you got to say the right thing, you can just type a message to the Copyright Office here. I mean, I would keep it pretty formal. And you can limit your claims. Sometimes I have done this if I'm registering like product packaging. Product packaging is only protectable for the very specific new and original arrangements and selections that went into the product packaging. Otherwise, it's very factual and very not protectable generally under copyright. So we make a very specific and required statement here that the claim is limited to the original organization, selection, and arrangement of this particular product packaging design. In most cases, you won't need to use this, but it's nice to have it there because it's the only place that you can say something other than the mandatory checkboxes that they give you. So just keep that in mind if you have a unique situation. And now we have completed the certification and you can review your submission. So this is where I was talking about when you print a PDF, it does not print well. It will cut it off, you won't get to see. It'll look kind of like what I've printed here where you can't even see all the fields off the side. So one trick here is to copy and paste it into a Word document so you can actually blow it up and see it and make sure that you don't have any major typos or errors in the process. Perhaps if you've got a nice browser that lets you select and only print the selection and you can make it fit on one page, that could be an option. It might also be 6 points and really hard to read, but it's your opportunity under review submission to kind of confirm that your name is spelled correctly, which hopefully it will be because it'll be under Add Me for you, and that you've got all your titles there. I don't have all the screens, but this keeps scrolling for each of those bits of information that you entered. It will all show up there. Once you have all of the check boxes done, you know that you're done. One thing that is nice, I'll give them props for user friendliness. If you see something under publication, and let's say you typed 2011 and you meant to type 2021 and you need to fix it, you can just click right here, publication completion. It'll just zoom you back to that section. You can fix it and push continue, because that's what is required to actually implement the change. Once you push continue, then you can zoom back to review submission. And so you can kind of bounce around to the extent you need to. That's also nice if you are doing like the save for later, and you can kind of come and look at where you are in the process and bounce around that way. So there are some nice features. I shouldn't be so hard on them. This screen is important because you can review. You can also save a template. And this could be something that you should play with when you're dealing with repeat submissions, like repeat in the sense of annual submissions. It might be something, at least until they completely revamp their systems and all of the code changes. But for a while, I think this type of mechanism will continue to be offered. Hopefully it'll be even nicer in the new system, but keep this in mind because it might expedite your workflows as you're doing these repeatedly. Once you have confirmed everything looks good, your point of no return, and that's kind of a lie because there's a trick I could show you, but essentially once you add to cart, then you're saying, I'm ready to pay. I'm ready. My application is complete. I told you there was 3 things you had to do. You had to fill out the application, you had to pay a fee, you got to do a deposit. Step 1, as soon as you push add to cart, is done. And then you will be taken to the pay screen. And notice like there's also this archaic looking thing. We completed the form and now we're at the pay stage. So you can kind of orient yourself as far as where you are. There's an opportunity here that if you're doing multiple registrations at once, if for some reason you want to wait to pay, you can add more services and go back and add another application. So you can pay for as many as you want at one time. This screen is old. It says it's $55. That's because it went up last year. This would actually say $65. And if you had multiples, it would just keep adding them together. If you're only doing one and this looks good and all of these pieces of information look correct, then you push checkout. And now you get to select your payment method. You can pay by credit card, as I told you about, and that takes you to the pay.gov website. You have the opportunity to do deposit account. Again, this particular type of workflow, if you do the template and the deposit account, might work for you. And it's something to definitely explore if you're going to be a prolific filer. Here's that secret I told you. You could also change your order. There's a couple of places you can abort, but you'd rather not if you can help it. So if you're going to pay with electronic funds transfer, then you will have the opportunity to enter your bank information. Recognize that from checks if you've ever seen any of those, or from your bank account. Or you can do a credit card. This very familiar looking field's required for the credit card. It's nice they don't charge you extra if you run it through a credit card. It is what it is. You will want to enter an email address because they'll send you a receipt. And actually pay.gov, at least last time I did it, unless they've changed it, will send you a receipt. So it's separate from the Copyright Office altogether. And it's a way to track that they received your payment. And once you enter your email address, any CC email addresses, you can submit payment. Then that will transport you back. Actually, this is the deposit account, what that looks like as an option. I don't use the deposit account, so I can't tell you a whole bunch about it, but it's an option. So once you've done that, notice that we've advanced again to submit work. Payment successful, hooray, they took our money. Now we get the option, or we have the requirement to provide a deposit of our work. Okay, so this is the screen that pops up for you to upload electronically the zip file or whatever file you are going to send to the Copyright Office. I don't find this screen terribly intuitive. Every time I go to it, I have to study it again. But this is where you review the instructions very carefully. You can look at the blue links, they're hyperlinks to give you more information about what the copy requirements, file type, size limits, all of those good details are for what you're submitting. You should see that this application, this is the case number. I know you can't read it, but trust me, that's a case number. Then the title, this should all tie together and look kosher for what you just thought you paid for. And this is the deposit of the work that you're making to the Copyright Office. It is absolutely required that you make some deposit of your work and that it has to be a complete copy. You want it to be legible in an assembled, orderly form. The title of the work should be included so that it can tie together with the application information that you inserted through the process. And you want to include everything being covered by the registration, so don't leave anything out. Hopefully you can upload it via Echo if you can fall within the requirements, and otherwise you have to send in hard copies to the Copyright Office. How many copies of your work depends on whether or not you have selected that it's published or unpublished. And if you've said published, it also matters whether or not it's in a digital form. This is the opportunity that you have. If your work is published, but it is published only in a digital form, then you can upload it electronically, and you would only have to upload one copy. If it is published in a physical form, like a book, you have to send in 2 copies, 2 physical copies. If it is published like in a gallery, you probably have to send in 2 physical copies of a photograph. So it's not just books, it can be photos too, or replicas of, like I was talking about product packaging, a beer label, replicas of that, like laid flat. We're not sending a beer can, but like the layout of the beer can label is what gets sent in physical form if it's published. If it's been offered on a beer can for sale, it has been published, arguably anyway. The other example that I was thinking of is a sculpture. You're not going to send in a sculpture, but you send in 3D pictures, like pictures from every angle of the sculpture. That is the representation of the work being registered. I think in most cases that also gets to be only uploaded because you're not submitting the physical work itself, but just a representation of the work. Once a deposit is submitted, it's part of the public record and it will not and cannot be returned to you. So make sure you've enclosed the right thing either electronically or in physical form. So if you get to qualify for electronic upload, so it's either an unpublished work, a work that was published only digitally, a published work for which the deposit requirement is the identifying material. That's the magic words I was trying to think of. Identifying material. That's what photographs of a sculpture are. They're identifying what is ultimately being protected. And published work for which there are special requirements requiring a hard copy deposit to be sent to the Library of Congress. So that's those physical works like I was telling you about. So if hard copy is required, then you submit the application and the payment like we already did, but then you physically submit the hard copies through the U.S. Postal Service. So if you're doing upload electronically only, you select the files for upload, and then it'll spin for a minute. If it's a really big file, it'll spin for a little bit. And that's after you click this says Start Upload. This is where you select your files to upload. So this is why it's so important, where I was telling you to have the folder already ready of the work that you plan to upload, because it'll just pop up and it'll just say, my copyright registration for December 7th, 2021, and you don't have to navigate around and accidentally upload the wrong thing. Once you have selected what you want to upload, you guys know this, you push open and wait for it to spin. Here is a link to the types of files that they accept, and there are many, 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 many types of files that they accept. They're pretty expansive for what they'll take. You can do multiples if you have, this has song 1, song 2, song 3 for my songs in this particular example. So there can be multiple uploads if you want, or you can zip them into one ultimate folder and do a zip file upload, which I definitely recommend. But you can keep selecting more until they're all uploaded. You have the option to remove which again, if you have titled your work before you uploaded it, it's super easy to tell that all the right attachments are there because it says song 1, song 2, song 3, song 4. It doesn't say video from last March. You know, it would stand out to you if it didn't belong there. So it's a nice little visual check before you have the opportunity to remove it if it's not right, before you push the red button and you can't go back. So I encourage you to check what you've uploaded. Yeah.
I'm looking at this spreadsheet for the photographs.
Yeah.
And there's a column for title of photographs and then file name of photograph
Mm-hmm.
and then the photograph number. So the file name, we can leave, like if we have a folder of our 750 photos,
And their IMG.
those as they're named. We just need to copy each of those individually and paste them into this spreadsheet.
Yes.
So it's 750 copy and paste.
Yes.
And then the title, can we just use the file name or does it have to be something else distinct?
The Copyright Office will not mandate what your title is. It could say, like that, this says song 1, song 2. It could, I mean, you could say, to make them match, right? Yeah, I don't disagree. Karen, do you know if there's any?
We like to make them descriptive, just so when we're going back, like, we're like, oh, we need to find that horse, you know, picture or something. Like, we can search the files for the name. And
Yeah, unless you have an index. Like, so what this is.
On our computer for that file name, it will pop up immediately.
Right. So the only thing the thing I foresee happening is like, I'm at the law school and I see a photo on the wall and it's a photo of a bucking horse. I don't know what the IMG number is on that. And so if I go talk to the photographer and say, did you give them permission to put that up or did they buy that from you or is that okay? Photographer, can you tell me whether that's registered? As long as you can tell me that it's registered and go put your hands on it, honestly, none of that actually matters as far as what the title is or what the IMG is. I can see why making them match makes sense, but at the same time, this is your opportunity to make an index of what the image is and tie it together with the random number that's in the metadata of how it saved the photograph. So I would say your comfort level on that, there's some examples where we see it come into play in our world. I definitely see how copying and pasting everyone could be easier when you're trying to do that many.
Words like in our editing software. So, and like if it was a horse photo, I can just search for horse and it would be like the 50 photos of horses that I've taken.
Yeah, and then you could find the IMG number and you're good to go, right?
The other way you could do it is keyword, like this was my 2021 copyright submission, and that all of the photos from that copyright would pop up too. So.
Right, those are good ideas and why I'm so happy you're here because you're thinking of it now instead of 5 years from now when it would be completely impossible to go back and figure it out later. So the pre-planning of how am I going to know what these are now and tie them together. If I've registered them, tie them together with the registration. Maybe you haven't, and that's fine too. The keywords are going to help you locate the subject matter. And I think one of your classmates was weddings. So like the Smith wedding from 2020, here's all of the photos for that. So sometimes the titles kind of become more easily, and sometimes perhaps they're more abstract or not easily identifiable for one reason or another. Yeah.
Can you publish a work, or not publish, can you submit a work that's unpublished, and plan to publish it, just so you don't have to do the send 2 copies?
Yes. I encourage photographers to register while it's unpublished because then it becomes much more clear. You just are sending in a whole bundle of unpublished works. But that's not always possible, so that's why there's other options too. Easier, yes. Okay, so be very careful. Like I said, this screen is not super intuitive. They've got the green button to select the files. The blue button says it's starting to upload. You'll see that they're actually uploaded because you see how many kilobytes or megabytes are there once they're there. But then you also have to click this one too. So when all the files for the application have been uploaded, no changes can happen, not even with any of my cheats. They don't exist. Once you click the green button, it's over, it's done. Off it goes to the Copyright Office. So this is for the electronic submissions. You will get a screen, this yellow bar that says your submission is complete. This will actually, after a while, will populate with what they think you uploaded, but it takes a while. You'll have to check back. So don't panic. If it's not there instantaneously, that can take a little while. But there's no way to add. Once this is done, it's done. And it has been submitted. You have to start over again. There's no way to supplement a deposit. So if you have decided that you don't get to do an electronic copy, then you have to click on and print a shipping slip. So you create the shipping slip down here. You skip all of this stuff that I've already been telling you about, and you go to the bottom, and you create a shipping slip. If you have done multiple applications together when you paid, I told you that was an option, then there will be multiple shipping slips, and they have to be, we usually paper clip them very carefully, like with a sticky note over top, but they have to be tied together. Your shipping slip has to match with what was in the application. This is what the shipping slip looks like. It has a barcode, and I've given you some very step-by-step instructions, which, honestly, I use when I submit them. Just how to print the shipping slip, fill out. Ideally, you can type this before you print it, but you can handwrite how many. Are you submitting 1 or 2 copies of what? So beer can packaging. You mail it to the Library of Congress. And like I said, you have to attach the shipping slip to each application before mailing it. They want you to mail it to them in a box, because if you don't, they might shred it, being afraid of anthrax from years ago. I also will encourage you to submit this declaration. This is a document that we created in my office. The reason for this certification of deposit submitted, you will not see this in the Copyright Office, you will not see it anywhere else except here, is because you don't get a copy of what you registered back from the Copyright Office. Like, ideally, if in a perfect world, you would send them 2 copies of what you wanted to register, and they would send 1 back to you with the registration certificate, but that is not what happens. All that comes back to you is a single piece of paper that has the information you typed through this process that we've been through tonight. That's all that comes back to you. So there is no way to tie together, other than what we've been talking about, like the index or the metadata, the particular registration certificate and the specific work that went to the Copyright Office. I am demonstrating this to you in a piece of paper, but it does not have to exist in paper. The first option here is that you are certifying that it is a deposit of an electronic deposit. And so you just enter the information that was either the read-only file, the zip file, whatever files that actually were uploaded, and the date of uploading. So this can be completed on your computer, never printed, never exists in paper, but it should be tied together, ideally in that same folder that you organized for this copyright registration. A copy of this should be saved there, and you should type. Typing can count, some way sign, because that makes it official in a legal sense as being a business record that you keep in the ordinary course of your business, and that means that it has the weight of evidence in the courtroom to tie what went to the Copyright Office together with the registration that came back. We do this in my office as a means to just back up what went to the Copyright Office. So once you have done either the upload or the shipping slip and gone actually to the post office and put it in the mail, then you're done. You've done all 3 of those steps that aren't up here anymore, but you completed the form, you paid the fee, you submitted the work. Except you're not done, because now you have to wait. You have to wait for the Copyright Office and track that deposit. So if you sent the physical deposit, you will want to send it with tracking, and you'll know that it got there. That's step 1. Good, checkbox. Then you have to wait and see if it comes back. 6 months is probably the minimum that you want to wait before you start harassing them to see where it is, because you won't get anywhere. But after 6 months, you should continue to check back. And through the ecosystem, you can monitor the online status. When you go back, you log back into Echo, it will show you can register a new claim. That's what we did today. It will also have your applications, called My Applications right here. And it also will list the things that have been submitted by you. Here again is the case number, tying together. Remember, you have to put it in that template. Tying together that particular submission, that it's still open, pending. This will change to closed when it is granted. If this says closed and you haven't gotten your registration certificate for like 6 months, because that happens, then you have to call and say, where's my certificate? Because it could get lost at their office. So once this changes to closed, you definitely want to be watching the mail and make sure it gets to you. The other information tying this work, hopefully you've got multiple rows here of many different works that are in various stages of completion, either open or closed. Once it's closed, once it comes back to you, again, here's that certificate of registration, the one piece of paper, maybe two if it was really lengthy, or your template made it really lengthy, but that's all. It's just literally what you typed into their system. But again, you still aren't done yet. You have to think about keeping these records for a long time because copyrights last for so long. If you have hard copies and you want to maintain hard copies, fine, cool, go for it. More realistically, you probably are going to keep these things electronically. So scan this piece of paper when it comes in and put it in that same folder on your computer that has your photographs and your certificate of deposit that you completed. So just tying it all together, and then just in your virtual file cabinet, everything's together, you can forget about it. Hopefully for a long, long time until there's an infringement, and then you can go back and pull it out. You want to preserve the file that you uploaded. So when you get a new computer, then I don't even know how many just terabytes of server space you guys have to have. It must be so big. But whatever that external storage is that you're going to keep forever and ever, make sure you preserve it somewhere so that it is in your deep, dark storage. But the better that it's organized, like we said, 2021, then it'll be organized in order at least and easier to find. You can preserve your originals in a safe place, hard copies of the registration certificates. These are possible to get duplicates. Like you can get another copy from the Copyright Office as far as the actual registration certificate if you had to. But if you have a place to keep all of them in a folder together, that's probably a good thing to do. If you have physical pieces of paper that are that declaration that I showed you, which is fine too, keep them together for sure. So what you're trying to do through all of this that we've been through tonight is to correctly register your work so that you have a way to optimize your registration system and ultimately be able to recover damages from infringers. And it's not worth your time, because it is worth your time. We're talking about a big difference in money when someone steals your work, which they will, because you'll have fantastic work and they're going to steal it. And this gives you some ability to make them stop. Keep as organized as possible, and as you guys have had great questions on that tonight, just organizing it for yourself so that you know how to replicate that once a year when you go back to do it. Make it really intuitive for how your brain works and how you're going to do it again and again and again. You can update your address with the U.S. Copyright Office, and I've given you a couple of options of how to do that. You can also record transfers. So if for some reason you do decide to assign your work to someone else, they can make a public record of the fact that they're the claimant and owner for that. It is also an opportunity for a way to track who the current owner is, like when the author has died, or if there's security interests and mortgages, and I don't know if we've talked about that. I don't think that we did. I told you in class that you can transfer through writing your copyrights. They're assets. We talked about them being property. They can be leveraged. They can be leveraged to borrow money from banks, and certainly the more organized you are and the more that you have stayed very consistent with your registrations, the more valuable those assets are, the more money you can borrow against them. So The banks might want to record security interests or mortgages through the Copyright Office if they've taken your work as security against a loan, and that's an option for them to do. We have a process in the United States that's called mandatory deposit of published works. This does not come up very often, but occasionally it does. There's a branch within the Copyright Office that's called the Copyright Acquisitions Division, who will send out letters to like authors who have not deposited one of their books with them. So they get to collect copies of everything that's published in the United States and keep it on deposit, regardless of whether or not there is any claim to the copyright registered. I don't want to dwell on this, but I do. What time is it? 7:30. I've been talking a long time. I was hoping to show you guys, since you are particularly photographers, that they have these online tutorials. Let me see if I can. To step you through some of this a little better.
To a group of no more than 750 unpublished photographs. There are strict eligibility requirements that must be met in order to register a group of unpublished photographs. Before completing the application.
Okay, I don't see how I can advance him. But these are available at the Copyright Office. And he will literally take you through each of the steps of the template, that index, and give you good ideas. I told you about the compendium. I also wanted to show you, maybe, did I pull it up? No, maybe I didn't. Oh, I think it's in Chrome. That's right. That they have also group registration tutorials that include the template and ways to fill it out. And see, okay, so they've done the IMG, making it match the file name, and then the group title too. So definitely dig into these. And I'm sorry I didn't make that more specific for you, because it was meant to be kind of more of a overall registration workshop, not just about photographs. But I do want you guys to feel special, because photographs are the only ones that get to do these kind of things. Like, no other area is this an option. So I know it looks overwhelming and like a total pain, but it's actually a great benefit that I very much encourage you to take advantage of, for sure. So what other questions? That is all of my prepared materials, and I've shown you some little bonus stuff that I hope you will go and look at when you get ready to do this. What other questions?
It's completely unrelated to photography, but are you familiar with NFTs at all?
Yes.
How does that work with copyright? It seems like it's its own copyright system.
It is a fantastic question that intellectual property is trying to navigate right now, the field, the law, because in a lot of ways, I told you about the first use doctrine, right? The first sale doctrine, I mean. In a lot of ways, NFTs are just like you print a photograph and give it to your friend, and your friend can do whatever they want with it. But can they mint it into an NFT and then shred the photograph? That's probably not what you were thinking when you handed it to them. And then there's all this talk. So like how much, so I say that like it comes up in the NBA stuff too. It's like how much control does the author get to exert over a copy of his work in the virtual world. So I don't know, do you guys know NFTs a little bit? So I had to learn about NFTs, and I did not know much about them. But the best way that I can like conceptualize what the heck this is it's like an ownership right for the metaverse. So one of the examples I was listening to is like the first artist who had created a home for a metaverse. So like selling homes, places that you can occupy as your emoticon self, your virtual self, your augmented reality self in the metaverse. And you want to hang things on the wall in your virtual house. You want to hang a very nice, fine work of art. And it might be the only one that's allowed to hang in the metaverse legally. So you want to have an NFT to establish the fact that you have that you're authorized either exclusively or non-exclusively, some way to display that work in your virtual world. So that's the only way that I can conceptualize why in the world anybody would want an NFT. But they also are property that are being exchanged like crazy. Sometimes, and it depends on the platform on which they were minted, created, validated. It's like a certificate of authenticity. So like fine works of art, when they hang on a museum, on the back of them, they have a certificate of authenticity. That's essentially what this is, only digital and in a source code version. So it's just code that establishes one copy of something and creates it in this virtual Bitcoin world on the blockchain. What I was going to say was that sometimes, depending on the platform that's used, there are contracts, licenses that all users agree to, and those are referred to a lot of times as a smart contract. From an IP standpoint, from an intellectual property standpoint, the smart contract is a good thing for artists, because if you are the artist, the original artist, and you mint your NFT and it's on a platform that has a smart contract, there's a way that we do not currently have in the United States right now for an artist to make money off of every single transfer for the life of the copyright, for the life of the work. Right now, if you sell me one print of your photograph, I buy it, I can turn around and sell it, and you do not get proceeds in any way as the original artist for that photograph's resell. Even if I buy it while you're, in school, and I get a good deal because you're a nobody right now, and then you turn into one of the most famous photographers in the world, then I turn around and sell it for like a 2,000% profit, you still get nothing from that. I get as the owner of that print, I get whatever profit comes from that sale of that print. In the virtual world with the NFTs, and if there's a smart contract, when I sell that for 2,000% profit, you'll get a cut as the artist under those platforms. So it's really exciting for artists to have that opportunity, that maybe that can happen. But there's also like the wild, wild west aspect of it, where if all of those things aren't true that I just told you, you can just sell NFTs any way that you want, and the artist won't get that trail of money in the long run. So I don't know if I answered your question, but I gave you a lot of information. What other questions do you have about NFTs?
No, it seems like its own copyright system almost, but like for the metaverse, like you're talking.
Yeah. I think, and so I've been teaching at the law school, and I'm trying to get these law students to think about, because it came up with Pulp Fiction, just like last week in the news. Quentin Tarantino, original script, handwritten, of Pulp Fiction. He sold that, and I can't remember which movie studio. Let's just pretend it's MGM, because I can't remember which one it is. But he sold the rights to Pulp Fiction when they created the movie. Like, he doesn't own those rights anymore. But he still had the handwritten script. And so he minted an NFT on that and proceeded to sell that. And of course, the movie studio was like, hey, wait a minute, buddy. Like, we paid you a fortune to own the rights for this movie. You don't get to sell the script, which is part of the movie, and put it out as an NFT. We get say over that. So for the law students that I'm talking to, it's like, you got to be thinking right now. Like, you're saying it's a unique copyright system. It kind of is, because that Quentin Tarantino example is like, when they filmed Pulp Fiction, what was Bitcoin? Like, what was blockchain? It wasn't a thing. And whatever we know now for the metaverse is not what it's going to be your life plus 70 years from now. So how do we think about, as lawyers, this transfer and this bundle of rights that I've been telling you about? Like, it's no big deal. It's like, well, what does that actually mean in the metaverse? And how do we actually, foresee that playing through in this virtual world that we're going to be existing in more and more?
Does the process of minting something into an NFT does that make it its own new work?
Maybe. Because, and so that's why you don't have the rights, maybe. In the example that I gave you, if you hand me a photograph that you've taken and I get a copy, that's my copy. Did you give me the right to create the derivative work of minting the NFT? No, is my answer to that. As an IP attorney, you did not. That was not within your thinking when you handed me the photograph. But that process of minting, I think, is a derivative work. And under copyright that I've been telling you about, you have the right to control that as the artist, unless you're Quentin Tarantino and you've contracted that away, you retain that right. So yeah, you should be able to control it. And then if you add the whole NBA aspect to it, you've got the tug of war between the contract that they signed to play in the NBA, the right of publicity that they hold as a personal right in whatever state that they're existing in, and then the fact that the NBA actually owns all copyright and all visual depictions of anything having to do with the NBA. So there's crazy intellectual property copyright issues at play. That is super interesting, and there's a lot to be figured out for sure. And the law will continue to be way behind the technology in trying to figure it out. So good questions. It's good to talk about it because I just usually read about it and don't get too. It is fake. But there are like Christie's, you probably know this, Christie's sold the first NFT for $69 million. And that was a collection of images, graphic images. And it's, like local Montana auctions are doing sales of NFTs. Like it's everywhere. It is definitely but I will say it's not new. It's been around for at least 4 years or more. NFTs have been around. It's just that they got really popular when like Banksy did something, like burned something and created an NFT, and then the Christie's sale happened then. And honestly, the pandemic helped that whole thing because it made it something to talk about that wasn't the pandemic, so it got a lot of news coverage and became very, very popular very fast. Cool. What other questions? Yeah.
I ran into it the other day, so I was designing a poster, and I went online to a font website where you can download free fonts, and included in that file is a little excerpt about how it's free for personal use. If you can't copyright it or trademark unless it's a logo, how does it come as a computer software? Is it just kind of made up to scare people away from using it for, say I try to sell the poster, is that illegal to do, or do you know anything about that?
I don't know the specific place that you're talking about, but it is absolutely an excluded area where typeface and fonts are not protectable under copyright. However, if you go to a website, you probably have agreed to their terms and conditions. So contractually, you may be agreeing to something that goes beyond what the intellectual property rights are. So perhaps there's something that you violated. I totally don't know what site you're on, but that's a lot of times how computer software can actually protect their software even beyond what copyright would allow, limit even what you can, the first sale doctrine I was telling you about, even limit transfers, your one copy to someone else, they can try to limit that contractually. So terms and conditions matter big time when it comes to getting something either from software or online. But generally, if you haven't agreed to something, like some limited license because of that, then font should not be protectable. And you should be able to put it on a poster for commercial use, not just personal use.
It's a weird thing, because all the fonts were made by different people.
Yeah.
And then some of them, when you download, include a little excerpt, and some of them don't. It's a text file within embedded in there. And I just always thought that it did have weight, but it's so confusing. I'm
right.
Are you going to come after me if you see this on a poster that just sold for a couple hundred, or are you just trying to discourage people from?
They're just trying to discourage, for sure. Yeah. I have a serious question about whether it's enforceable at all, but people can. There are lots of lawyers who will take really crappy lawsuits to court, and you don't want to end up in court. So to the extent you can avoid having any attorneys in your life, and that's the theme of our next class when we get together in the spring, how to avoid having attorneys in your life, trying to navigate the very confusing waters of Creative Commons, whether it's fonts, whether it's imagery, whether it's photos, because you also, as producers of artwork, have to make those decisions for yourself. What am I okay with people doing on this? What am I going to make the particular licenses or attribution rights or any of that say for your own work, too? It's not easy. And you feel better. Yes, two things. So the first thing is I think the certificate is in the slides that you have, but second thing is you can have these slides. This set. this slide deck too, if you want it. And it's in there too. And what I could do on this is I could append like a cleaner copy. Like, so it's not just the JPEG on the slide. I can like attach an actual piece of paper, like a white version. I don't know what I'm trying to say, but you know what I'm saying? Editable.
The lecture come through, but maybe I haven't looked.
I don't think it was.
I don't think it's been posted.
Okay, well, I did send it to Jessica. So you guys have like a Moodle or a file share or something? Yeah. Oh, Teams, okay. Yeah, she definitely has it. But if you come and write down, I don't get your email addresses or anything. So if you want me to send you stuff, if you come write down your name and email address, I will send you. Yes.
Or upload it, because we have the power to do that, so I could share it with the class as well.
Okay, cool.
Jessica's job for her.
Yeah.
Thank you.
Yeah, thank you guys for coming.
It eased a lot of my the burden that I was feeling from class the other day, so it seems a little more straightforward.
Yeah, well, good. I'm glad to hear that. I do hope that utilizing the tools like the templates and the add me should make it like start to get where it goes a lot more quickly. And definitely the hardest part is always going to be this index thing. But I know, if you're really good at Excel or whatever spreadsheet, sometimes you can just do this +1 and drag it, and it'll auto-populate the whole list. So there's definitely look for those tricks in particular software that you're using to not make it so painful.
I have one last question.
Yeah, please.
So I, like, somewhat frequently will photograph concerts.
Oh.
And they're, like, it's complicated how they send. Some concert venues don't care, and it's like, oh, there's no paperwork involved. But, like, the Wilma and everything that Logjam does have paperwork, but it doesn't talk directly about copyright. It just talks about their usage and, like, how I can get usage, but it has to be with, like, written consent and stuff, and, like, they don't care if I use it for socials, but, like, they said I can't, like, sell prints or whatever. And then it doesn't really mention if they can sell prints, because if they don't actually hire me, like, does this kind of like contract, does that override it? And is it like legally binding in that sense? Or is it also one of those things that's like, oh, we're trying to safeguard, we don't want you to get more clout than we do for your photos that we let you take in our building?
It's more like the latter. So you ask very good and very complicated questions, and there's lots of layers to the answer. So first of all, it's access, right? So they grant you access to take photos, and they can restrict that access to the extent everybody agrees that it's restricted. But at the same time, the default rule in copyright is that the author, the person taking the photo, owns the photo unless they transfer those rights away. So unless the transfer of the rights away can happen without a signature if it's not the whole assignment. So you can transfer little bits of the right to publish and the right to reproduce, and those little bits can go away just because of whatever you agreed to enter the premises. You still own the copyright, and as long as you don't sign that piece of paper that transfers the copyright, you still are author. You just might have restrictions on that based on what you've agreed to with them. And it can get super convoluted for the reasons that you're saying. Yeah. Also, the actual performers, sometimes like the performers have limitations, the venue has limitations, maybe the promotion company has limitations. Like,
everyone's like limiting each other.
Mm-hmm. Yes, they want to limit each other, and they know that the reason they don't really say what you can do is that they know that you own it, that you own the underlying work. So that's why they're probably a little bit like mysterious about that. But definitely always read, no matter what facility you're entering, like what they're proposing to limit you. And many times they'll be overreaching and not even enforceable. But again, you don't want to end up in court. So just trying to get it clarified if possible up front would be what I would recommend.
And not go against something that you signed that you like.
Don't go against something you signed, because contract's a whole other ball of wax. From, ownership and use are not the same thing. So if you've signed away those rights, then you could get in a contract battle that you don't want to be in.
Yeah, a lot of it's like them saying, like, unless this has been specified by us. And I'm like, Okay, so I can sell prints, but only to you.
I think it sounds like you're pretty savvy on this. I think you're gonna be okay, yeah. Yeah, thank you guys for coming.